legislation as a part of Declaration of Human Rights of protecting the interests of linguistic, ethnic, religious minorities, cultural minorities throughout the world. The very next year, India was ready with the legislation, and the National Commission for Minorities Act was passed. So this commission which you see today is a statutory commission created by a statute. You have constitutional commission which are created under the constitution, like the SC/ST commissions, and this is a statutory commission which owes its life to a particular statute or a legislation. So effectively, this commission was created I will explain the various functions, etc., and it will be also covered by the Deputy Secretary in his presentation. But effectively, it is to cover cases where there has been a minority has been wronged or discriminated against, or its rights are deprived by virtue of being a minority. This is a very, very important distinction. The crux of the matter, and which is very often misunderstood all over the country, even by lawyers, judges, courts, etc. So this has to be borne in mind. So this commission is of 7 members. At least 5 members, including the chairman, must belong to a minority. The other 2 could be non-minority. Though in effect, of course, mostly all members of the commission have been to one of the notified minorities or the other. So after this legislation, 5 religious minorities were notified, with Muslims, Christians, Sikhs, Jains and Parsis. And sometime in January 2014, in the last days of the UPA government, the Jains were also added. So there are 6 religious minorities, and this distinction is very important in the law, as we shall see. That originally the discussion started with religious and linguistic minorities, but effectively it came only to 6 religious minorities. So at the central level, and I'll come to the state level in a minute, there are only 6 minorities by virtue of their religion. Now, the power to legislate on minority issues is a concurrent power under the Constitution of India. So the central government can also, the parliament can also legislate, and state legislatures can also legislate. So it's a concurrent power, and each cannot, it is within the jurisdiction of each. So the various states have also set up, not all of them, as you will see in the statistics, about 18 states have set up a state minority commission, which some of them are statutory commissions, some of them are non-statutory commissions. And these, they deal at the state level. Now here, pausing for a moment, coming to the main issue, that in 2002, there was a very important judgment which was given by the Supreme Court by an 11-member full constitutional bench in the case of T. Pai Foundation, in which it was said that minority status will be decided at the state level, not having regard to national population, or having regard to the state level who is a minority or who is not a minority. So by virtue of that definition, in states like J&K, in states like Punjab, in states, some of the northeastern states, in some of the union territories of Lakshadweep, Ladakh, etc., Hindus are a minority. And this judgment today is good law. Various attempts have been made to whittle it down, but it's good law. So at the central level, you have 6 religious minorities. At the state level, following the Supreme Court judgment, there could be minorities. Now, 2 states have already acted on this, Maharashtra and West Bengal, and they have notified Jews as minorities. Although Jews are not a minority before the National Commission for Minorities. So there is a lot of confusion, there are a lot of public interest litigations have been filed saying declare Hindus as a minority in some of these states, etc. So this is a very hot issue which has been debated, and as we discussed in considerable length in the earlier session, there is a lot of confusion, there is no clarity because it's concurrent jurisdiction. With this little backdrop in mind, as far as the commission is concerned, apart from hearing grievances and complaints, etc., of minorities which have been deprived of their rights or which have been discriminated against, it also conducts studies carries out research to independent research groups, prepares report like the Satcher Committee report, some of you may have heard about it, or the socio-economic conditions of minorities. Effectively, it sees whether the safeguards provided by the law are being implemented, the monitoring of safeguards, whether they are being implemented at the ground level or not. The Commission makes several ground visits to various states where atrocities, violences happen, and does a study. Effectively, the Commission has been vested with the powers of a civil court. That is, they can summon witnesses, summon attendance of authorities, summon for records, public records, and so many powers of the civil court under the Code of Civil Procedure are vested in the Commission. However, there is a very important difference that unlike courts, the decisions and directions of the National Commission of Minorities or any of these commissions, state level commissions, are not binding. So in the sense that if you violate a court order, there could be contempt, there could be various sanctions which will follow. That is not so as far as the Commission is concerned. However, the Commission in practice, the directions of the Commission which are given to the police, to the district authorities, government officials, are in practice there is a very high level of compliance, because the Commission makes a report of its recommendations to Parliament, which is a report to the government, and the government has to put before the Parliament, saying which recommendations have been accepted and which recommendations have not been acted upon. So there is parliamentary scrutiny, and if there are state level things, then it goes before the relevant state legislature. So there is a political parliamentary scrutiny which results in effectively the powers of the Commission are not only persuasive, but and in practice, as I said, there are no statistics available, but perhaps it's as high as 75 to 80% of compliance rate of directions given by the Commission. Now, as I have repeatedly said on this issue, that it is very important to note that it is not every complaint which concerns a minority. There could be property disputes between the minority community itself, like intra-community disputes, which say between two Christians. Those are not covered by the Commission. Or which are sub judice, which are pending before a court. First, you have to carry out the judicial redress wherever it is available, legal redress wherever it is available. Only then, if you find, for example, that an atrocity has taken place and the police is refusing to file FIR, then you come to the Commission. The Commission will process the complaint. The Deputy Secretary will explain in his presentation how the complaint procedure, grievance mechanism works, and a report or a reply is sought from the concerned authority, and if it is not satisfactory, again this goes on, and finally the chairman and the members have a hearing. There is a court hearing room where a hearing takes place and the directions, rulings, etc. are given. So this part, that there should not be overreach on part of the courts, overreach on part of the Commission, is very important. I think with this background, I will hand over to the